I am.
Okay, so I'm going to do all the work. Welcome, everybody. We're so excited to have you in class today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And today's 30-minute class is all about the 14th Amendment, looking really closely at the 14th Amendment from its writing in the 1860s to modern court cases, examining the 14th Amendment through the Supreme Court. Now, I am not doing this alone, thank goodness. I am here with one of our top senior fellows in constitutional law, and his name is Tom Donnelly. Tom, would you like to say hi to everybody?
Hi, everyone.
You're as excited as I am with this topic, right?
Oh, absolutely.
And Tom's expertise is around the Reconstruction era, where really that is when the 14th Amendment is written. So we have a lot to go through today, but we wanted to make sure that you all know that we love questions. So open up that chat, use the Q&A, whatever works best for you. Ask us questions throughout the class, at the end of class, whenever they pop into your head. And we'll make sure we weave it in and ask them out loud as well, because we think questions are great for all of us to make sure we understand it. So Tom, as we're thinking about the 14th Amendment, I thought it would be helpful for us to ground the students in what is the Reconstruction time period, how this is not just one amendment, it really comes out as a bam, 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 a 3-amendment package at the end of the Civil War. And then I thought we could dive into the words of the 14th Amendment and what they mean to them, mean to us now today. How does that sound?
Sounds perfect.
There you go. Let's start with your favorite era, Reconstruction.
Absolutely. So just to make sure we're on the same page, Reconstruction is that era right after the Civil War. And so we as America, we're asking some really big questions. What we're trying to do is we're trying to say, what can we learn from this bloody, bloody war that we just fought? And now, we're moving past a society where, all the southern states have slavery. We have African Americans laying claim to American citizenship. And the question also becomes, what do we owe them? How do we make sure that the Declaration of Independence's promise of freedom and equality fully applies to them as well? And so what we end up doing is as part of this process, we ratify a series of transformational amendments. Now, we often think of this as America's second founding. And that's really bold to say that, but it's absolutely true. These amendments transform the Constitution forever. So with the 13th, which is ratified in 1865, so right in that year that the Civil War ends, the 13th Amendment's ratified, it abolishes slavery. The 14th Amendment is ratified in 1868, and it does a lot of things, and we're going to talk about them in a little bit, but fundamentally, it writes the Declaration's promise of freedom and equality into the Constitution, and we'll fill out what that means in just a moment. And then finally, with the 15th, it's ratified in 1870, and it bans racial discrimination in voting. So slavery, freedom and equality, expanding the right to vote, that's the heart of America's second founding.
Awesome. And one of the students did ask, so what is the 14th Amendment? Which I love that question. It's twofold. One, an amendment is anything that's added to the Constitution to either give more information to the Constitution or more ground rules of how we work in our government, or it kind of edits or fixes the Constitution. But to really understand what is it, let's look at it. So Tom, I have so many things highlighted here. It's hard not to highlight the whole thing. And guys, this is just section 1. It's a long amendment, but this section 1 has a lot of meat in it. So Tom will walk us through all the colored highlights and why did they pick these words and what were they doing with the words that they picked?
Absolutely. So we see here, it feels like a big wall of text. It is it really is. It's almost like a constitution unto itself, because there are 5 sections to the 14th Amendment. But we're going to focus especially on section 1 here and then section 5. And what I'd like to do is organize it around the 4 big ideas that I think you should pull from the 14th Amendment. So the first one is birthright citizenship. And so with that, that's that first sentence you see, they are all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So with this language, with the Reconstruction generation, what they were trying to say is that the Dred Scott decision was wrong. African Americans can be United States citizens. African Americans did have rights, which the white man was bound to respect, and that everyone born on American soil is an American citizen. So that's birthright citizenship. The second big idea here, Kerry, is freedom. And here we see that at the beginning of that second sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. That may sound really overly technical, overly legal, but what that really comes down to is we are going to protect important rights nationally. And so for the Reconstruction generation, what they had in mind was, remember, the Bill of Rights, which was added to the Constitution just a few years after the ratification of the Constitution itself. It has important protections like free speech, religious liberty, but the Bill of Rights originally only applied to the national government. And so here with the 14th Amendment, what this generation is looking to do is say, no, all of those important rights, they're going to apply to the states as well. Because what we've learned from slavery, what we've learned from the Civil War is our liberties aren't just threatened by the national government, but they're threatened by the states too. So the first two big ideas, birthright citizenship, freedom. The third one is equality. What's more American than that? Equality, the push for equality. And here the thing to remember is that the 1787 Constitution, the original Constitution, was silent on the issue of equality. And here with the 14th Amendment, with that language at the end, nor denied to any person within its jurisdiction the equal protection of the laws, we finally write the Declaration of Independence's promise that all men and eventually all women are created equal right there into the Constitution. So that's birthright citizenship, freedom, equality. The last one is national power over civil rights. And so this is Section 5 of the 14th Amendment. And so here the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Remember, this is the 13th, 14th, and 15th Amendment, these Reconstruction amendments written and ratified after the Civil War. These are the first amendments that enlarge, that increase the power of the national government. And so we're giving the national government more power, in this case, to enforce everything that's written into the 14th Amendment. Now, I don't want to mislead. This doesn't mean that suddenly national government is all powerful. But what it does mean is that we're saying the national government, we've made the judgment after the Civil War, the national government needs to do more to make sure that slavery is in fact abolished, to make sure that freedom and equality are protected nationwide, and to make sure that we really do ban racial discrimination in voting. And so, Kerry, the big idea here,
No, I think you're great, but there was some questions, and it goes back a little bit here. So first of all, for our students, and I'm going to answer the other questions in their chat as well, so I'm getting there for the teacher that's having a login issue. But number one, it feels a little shocking to me, I'm just going to say it, that the idea of freedom and equality isn't in the Constitution until 1868 in this amendment. Is that kind of like it's in there in some way, but not in there in this kind of robust way that the 14th Amendment adds it?
Well, I would say in terms of it's something that's clearly written to the Constitution, meant to apply nationally and meant to apply to the states. The 14th Amendment was really, really get it in there. Because if we remember for the founding generation, it's not as though they didn't care about freedom and equality, but they believed that the mechanism of government, that separation of powers, checks and balances, a government of limited powers, all of these sorts of things would most ensure that our governments at all levels promised freedom and equality to everyone. What we learned from the experience up to the Civil War and the Civil War itself is we need more protections in there. We need them to be more clearly stated. And so we do that with the 14th Amendment.
And then one of our students from the Shore Middle School asked, so does this mean that it does not apply to immigrants? So can you kind of parse out the words for us? We understand that that first part is about saying if you're born here, you are a citizen, period. And it's cleaning that up because that was a debate before it. But then do these freedoms and equality and due process, does that apply to immigrants as well? And then I'm going to make you squeeze it a little further to what about Native Americans?
Yeah, absolutely. So, I mean, the language of the amendment, and this is where the two mentions there you see of any person is so important, because those protections of due process, those are protections of the equal protection of the laws, those things apply to everyone. They apply whether you're a citizen, a non-citizen, whatever. And that was absolutely essential to the vision of important Reconstruction founders like John Bingham, who we'll talk about, I'm sure, in a little bit. So those are just things that were meant to apply broadly. What was the other question, Kareem? So, Native Americans. And so what we see here is, broadly speaking, you would see rights apply to Native Americans, but we do see in that the language there, and subject to the jurisdiction thereof, in that first sentence, the citizenship clause, was meant to at least leave Native Americans initially out of the promise of birthright citizenship. And so it would take a law passed by Congress in the 1920s, after some Native Americans fought for the United States in World War I, to give full citizenship rights to Native Americans.
Awesome. So as you think of like these big ideas, birthright citizenship, protection of equality, protection of freedom, Congress has more power to do and act on this. We have to think about, why did they put him in the first place? So I think this kind of leads us really quickly to, the Dred Scott case and what happened with Harriet and Dred Scott, that they had to put birthright citizenship into the Constitution. And then what's one of the first tests on this that we see with a person who has immigrant family coming and living in the United States?
Yeah, so Dred and Harriet Scott, this is an important case before the Civil War, 1857. And Harriet and Dred Scott petitioned for their freedom. They're enslaved people, but they're brought over onto free soil. And they say, we're free. We are now free. And they ask the Supreme Court to recognize this. And what the Supreme Court says in an opinion by Chief Justice Roger Brooke Taney are that, one, you're not United States citizens. And two, in really harsh language, that, quote, you have no rights which the white man is bound to respect. And so you see the Republican Party, the party of union, the party of Lincoln, the party that won the Civil War, part of what they argued was Dred Scott was wrong. It was wrong the day it was decided. And so now that we've won the Civil War, now that we have power, what we want to do is make sure the Constitution makes that crystal clear. And so that's what, in part, what that first sentence in the 14th Amendment is about, promising birthright citizenship. And so we see this, there's some debate as to how far that's going to reach throughout this period. While they're arguing over the 14th Amendment and during this period, we see a key case. I think what you're thinking of, Kerry, is in 1898, the case of Wong Kim Ark, which involved, in this case, a Chinese citizen in the United States. And so, Wong Kim Ark, born in 1873 in San Francisco, his parents are Chinese citizens, but he's born here in the United States. And so he leaves the country to visit his parents at some point in time, tries to come back into the US, and we've passed some laws that were harsh against the Chinese during this period. And they say, no, we're not going to let you in. You're not a United States citizen. They try to keep him out of the United States. He brings his case challenging and saying, I am a United States citizen. I was born here. My parents may be Chinese citizens, but I was born here on American soil. So this case ends up all the way at the Supreme Court. And the Supreme Court says, Wong Kim Ark, you're right. You are a United States citizen. Your citizenship passes from where you were born, the soil you were born on, where you were born was subject to the laws of the United States. It doesn't pass down from parent to child. It's rooted in soil, and it's written into the Constitution. And that's what we get from Wong Kim Ark there in 1898.
And just so our students understand the time period, there is a lot of pushback in this time period from Chinese families immigrating to the United States, and we're seeing a robust kind of pushback on that. That's why we have this clip here, so you can kind of see all the things that they're questioning, not just citizenship, but the right to vote and other things as well. I just want to make sure we're setting up the social time period as well.
Well, and
now,
Kerry, the last thing I'll say, Kerry, is the debates you see here between the majority and the dissent resonate all the way through today, when you see debates over whether undocumented immigrants' children are United States citizens. And you see the same arguments on either side that you see at the Supreme Court in Wong Kim Ark, with one side, the majority saying it follows from soil where you're born, and the dissenters, the other side, saying, no, it follows from your parents. And so these debates existed then, they exist today.
And thank you for saying that. This gets me so excited. This is why we talk about the 14th Amendment so much, because you hear stuff in the news and in politics and in your classrooms about what is citizenship, what is the right to, who has the right to vote, what is the balance between what the national government does and the state government does, federalism. You see things and have conversations around domestic terrorism. That's all kind of integrated into this time period of Reconstruction, but the meaning of equality in America, and that's where we're going to go next. All those things sound like modern conversations, but they're also connected to the Reconstruction time period. So when we think about that and we think about the protection of equality to everyone under the law, this Constitution, this Bill of Rights is all of ours. I'm going to bring it back to one of your favorite people, Bingham. So tell us what this guy who wrote it, well, one of the main writers, what was he thinking with this amendment?
Sure. So John Bingham, he's an Ohio representative in the U.S. House of Representatives. He's a member of Congress, a leader of Congress during Reconstruction. The great Justice Hugo Black described John Bingham as the James Madison of the 14th Amendment. And in many ways, that's a great way to think of him. He was there writing this amendment, and he was there even after the amendment wound up in the Constitution, still in national government, arguing over its meaning. And so Bingham's this amazing figure that we often forget, but is absolutely central to the American constitutional story. And so what happens is Congress passes this amendment in 1866, sends it along to the states for ratification, and we have this amazing moment. We have an election in 1866 for members of Congress, and we have President Andrew Johnson out there arguing, saying, do not ratify the 14th Amendment, I oppose this, and elect people who support me. And then you have John Bingham and his fellow Republicans saying the 14th Amendment is essential to America's future. And there's this great line that he has while he's out there on the campaign trail that I'd like to read. This was, in many ways, this framer's vision of what the 14th Amendment would do when it came to equality. He said he sought a, quote, simple, strong, plain declaration that equal laws and equal and exact justice shall hereafter be secured within every state of the Union, guaranteeing equal protection for any person, no matter whence he comes or how poor, how weak, how simple, no matter how friendless. And so it's a bold vision of equality, but you could see how it resonates all the way back to the principles that we wrote into the Declaration of Independence at the very beginning of this nation. And what's amazing, Kerry, is for a brief period, this actually works. We see in the South a period of a genuine experiment in multiracial democracy. And we have African-American governors, US senators, US House members, members of state legislatures, all the way down to local sheriffs. We see African-Americans participating, voting for the ratification of the 14th Amendment and 15th Amendment. So we see it work, but for all too brief a period. And so we see a pushback. We see a pushback from white violence in the South, from groups like the Ku Klux Klan. We see a growing indifference in the North from white Northerners. And then we also see the Supreme Court involved in the pushback against Reconstruction. Maybe the best symbol of this is the infamous decision of Plessy v. Ferguson, which is in 1896. And so here it's less than 30 years after the ratification of the 14th Amendment, we see just how far these rights have been trimmed back. And so what happened here? Well, Louisiana passes a law in 1890 requiring separate cars on their rail cars between African Americans and white passengers. So it's a classic Jim Crow law separating African Americans from whites. Who's Homer Plessy of Plessy v. Ferguson? Well, Homer Plessy's an African American in Louisiana. He's chosen to bring a test case against this law, trying to challenge its constitutionality. And the argument's simple. His argument is basically, read the 14th Amendment. Don't you remember what we literally just did less than 3 decades ago? We promised equal protection of the laws. How is this consistent with that promise? And the Supreme Court, in a 7-1 decision, said, no, Mr. Plessy, you're wrong. Louisiana's right. This Jim Crow law is constitutional. It is constitutional to have separate but equal facilities. This is consistent with the traditional power of the states to protect the health, safety, and welfare of their citizens. And there's nothing on the face of the law that suggests African Americans are unequal. And if African Americans take the law that way, that's their problem. That's effectively what Justice Brown says. It's a very harsh opinion in many ways. And again, it's 7-1. But remember, there is the one. There's a powerful dissent. And this is a great reminder of the power of dissents in American constitutional history. This is the opinion that people remember most of all because it keeps alive the 14th Amendment's true promise of equality. Its author is Justice John Marshall Harlan. And in many ways, he's a really unlikely author. He's an old slave owner from Kentucky. He opposed Lincoln in 1860, supported John Bell. He opposed Lincoln in 1864, supported George McClellan. He opposed the Emancipation Proclamation. He opposed the Reconstruction Amendments, but he changed. History changed him. He saw the white violence against African Americans. He saw the waves of oppressive laws against African Americans, the rise of Jim Crow in the South, and he changed. And he became the strongest voice for a broad reading of the Reconstruction Amendments on the Supreme Court at the time. And what he says is exactly probably what you're saying to Justice Brown right now, which is, Justice Brown, are you crazy? Are you crazy? You really don't think this law in any way brands African Americans with a badge of inferiority? That's what this law was completely about. And to say otherwise, you're either deluding yourself or you're lying. I mean, that's effectively what Harlan's saying to his brethren. And again, he's the lone dissenter here. And there's this great passage. Do I have time to read it, at least part of it, Kerry? Because it's so powerful.
Yeah,
No?
and I just want to no, I think you can. I think I just want to make sure that the students are looking at this and watching people like Plessy fight and say, this is not fair. The separation and saying, as long as we keep it separate and it's equal, it's fair. First of all, we all know it was never equal, but that's not the point. Separate makes you feel different or wrong or below. And this is what Harlan says. Are you kidding me? This separate is not equal. Don't kid yourself. And so sometimes we do this in history. We say, we think back like, oh, did they not get it back then? Like, did they not know how bad it was? And it's almost like we forgive them. And this is what I love about Harlan's thing that you're going to read. He's like, no, we know exactly what we're doing. We're putting somebody below and we're doing it based on race, and it's wrong. So I just wanted to kind of call that out for our students. He is calling them all out on it in the court case and going in the record as well on this. So go back to your quote.
Yeah, and remember, the majority they're reading this opinion as they're putting together their opinion. So they have to wrestle with what Harlan's saying. And what he says, and here's the famous passage. This is John Marshall Harlan in Plessy, his dissent. In the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. And so it was. Plessy became just as infamous as Dred Scott.
And so a couple questions that are coming in from the students. One, clarification about the Kim Wong arc. How did they know in the first place that he was a citizen the first time he leaves the United States to go to China and then comes back? Was there documentation that people had at that time? It's kind of a technical question.
I mean, there must have been. I'm guessing. I have to say, I don't know the factual context. I'm guessing he must have had something like birth certificates that could justify it. But there must have been some administered record. But I mean, at the very least, he was filing in court claiming his own citizenship. So there's that too. I mean, you're filing under oath that you are a United States citizen and were born here. So, but I'm not sure. I don't remember the factual context.
Awesome. And then this is more of a comment, and we're going to look into this. So the student was just wondering, did America completely ignore the 14th Amendment? Because do we really see equality anymore? And so what I kind of wanted to point out with that is people like Plessy fighting to make the words that are in the 14th Amendment apply to all of us. And that's what I think is the most hopeful of these stories of American history. We can see all these setbacks, but at the same time you see these setbacks, look at these amazing people that without hope still keep fighting. That's the best of America. That fight to ensure that our Constitution isn't just a bunch of values we put on paper, but are principles that we live every day. And another great example of that is Brown versus Board of Ed. And that will bring us to Loving and Obergefell as well. All these great people fighting to say, no, this is my Constitution, so it better apply to me as well. So walk us through, we've got 7 minutes. We got three on deck.
All right, perfect. So Brown versus Board of Education, we're flash forwarding to 1954. Linda Brown, who is she? She's a 3rd grader in Kansas. And what does she want to do? She just wants to go to the school that's closest to her house. It's the Sumner School. It's 7 blocks away. Instead, what she's required to do is walk 6 blocks to a bus and then be bused away to an all African-American school. She's only denied admissions to that local school because she's an African-American, and they make it an all-white school. The government makes it an all-white school. And she's saying, this isn't fair. This violates the 14th Amendment. And so in Brown versus Board of Education, we see Linda Brown brought together with similar students from across the country. And so it's from a variety of states, everything from Kansas out west, South Carolina in the deep South, Virginia in the upper South, Delaware in the border states. I know we have some people in Delaware here, and then Washington, D.C. So we see that there are problems of racial segregation in the schools in states throughout the nation. And so what we see here is what Linda Brown's forcing the court to do. They have to come to grips with, on the one hand, the text of the Equal Protection Clause saying everyone's entitled to equal protection of the laws, and the court's precedent in Plessy versus Ferguson, which says Jim Crow laws allow for separate but equal facilities, and so that perhaps school segregation is constitutional. And so Brown presents this issue to the court. And what the court does in a unanimous decision written by Chief Justice Earl Warren is it says, Linda Brown, you're right. We were wrong in Plessy versus Ferguson. Plessy versus Ferguson was wrong the day it was decided. Segregation in public schools is unconstitutional. Separate is inherently unequal. So once you separate people, even if you made the facilities equal, like Kerry said before, of course they were never equal, but suppose they were, even that alone brands you with inferiority and makes you a second-class citizen in the United States. That violates the 14th Amendment. And it's a really amazing decision for a couple of reasons. One is that Chief Justice Warren, he really brings the entire court along. Not everyone wanted to sign on to this opinion initially. He knew it was important for it to be unanimous. And so he got every one of the justices to sign on. And he wrote a very simple, short opinion that he hoped would be reprinted in newspapers throughout the country so ordinary Americans could read it. And it was reprinted and it was out there. And then the last thing to note, Kerry, is connecting with your Homer Plessy point, is that this decision didn't just come out of nowhere. This was the product of decades and decades of hard work on the ground in politics, in the courts, pushing against Jim Crow. And, you know, inside the courts, it was a series of cases brought by the NAACP, its leader, Charles Hamilton Houston, his protege, Thurgood Marshall, challenging segregation in a lot of other areas, like in colleges, like in law schools. They won case upon case, built up precedent that helped them, and eventually they won the big one. This was the controversial issue. They won it. With that, the Supreme Court declared school segregation unconstitutional. The court would then similarly declare Jim Crow unconstitutional in a lot of other contexts. And about a decade later, with the Civil Rights Act of 1964, Congress would write these protections into the law. So that's at least the first act here. Should we go to Loving, Kerry?
Yeah, I'd love to go to Loving. There's just one more kind of piece around this as we think about this like bubbling up. Do you want to just say a little bit about the doll test? Because I think a little bit about the Clarks and the doll test, because I think it's fascinating that the Clarks are a husband and wife scientific team. They're psychiatrists, and they come in and they prove it. And then they redid the doll test in the last 10 years, and they still found the same results. So going back to the student's question is, are we treated equally today? When they redid this doll test, they're finding this inequality still in existence in the way people feel.
Yeah, so I mean, in part, what Chief Justice Warren does in his opinion, he relies on some of this sociological research that Curry's talking about, which gave children of both races dolls of both races, and they found that even African American children would view the African American dolls as inferior to the white dolls, and so really showing that this feeling of inferiority extended quite deeply, and so reinforcing the legal conclusions that the court reached in Brown versus Board of Education.
Awesome. So next court case is Loving v. Virginia. So talking about marriage and who can marry, and then having freedom to marry who you choose.
Yeah, so this is Mildred and Richard Loving. They were residents of Virginia. Virginia has a law that says interracial marriage is illegal. It was one of 15 states that still had laws like that on the books in 1967. These sorts of laws extended all the way back to the 1800s. So Mildred and Richard go across lines to Washington, D.C., get married, come back into Virginia. They end up, arrested, tried, found guilty under Virginia's ban on interracial marriage, and they challenge this conviction under the 14th Amendment. And they argue that, effectively, what could be a greater violation of equal protection of the laws, and furthermore, the 14th Amendment's promise of freedom, than saying that we can't marry who we want, for reasons of race. And the Supreme Court, again, in a unanimous decision, agrees with Mildred and Richard Loving. And what they say, here is, again, effectively that the 14th Amendment has a promise of freedom and equality. One, from the perspective of equality, what is more quote unquote odious? That's the word that the court uses, odious, than distinctions made based upon race. And so from that perspective of equality, the Lovings must win, but also from the perspective of freedom. Because what's a more fundamental American freedom than the right to marry? And this violates that right for no legitimate reason. So that's Loving v. Virginia.
I love reading. And so we try to encourage students to read these court cases, the opinion and the dissent too, because it is moving when you see some of the opinions in this case, as well as in Obergefell's case, saying like this idea that you have the right to choose who you marry. And marriage is something that people are coming at this and saying, we're going to support each other for life, for better or for worse. And I think when I think about Obergefell and I think about that story, and I think about how part of the story is that the Obergefell's husband had
ALS.
disease. Yeah, thank you. God, I couldn't get the initials out. Had Lou Gehrig's disease. And they wanted to be recognized as a married couple because that is something that you do as a married couple, is you take care of each other in the worst of times. So tell us about Obergefell. I know it's a consolidated case, but his story really kind of resonates with a lot of people as well.
Yeah, so it's Jim Obergefell. He's an Ohio resident. His husband's John Arthur, and his husband dies of ALS during the litigation here. But in Ohio, marriage is limited to a man and a woman under the law. And so here, what Obergefell wants more than anything is he wants to be recognized on his husband's death certificate. That's the main remedy that he wants here. He wants their spousal rights. They themselves wound up flying, I think it was to Baltimore, to get married on the tarmac in a plane, come back to Ohio. And this is what Obergefell is asking for. And so we end up seeing them bring their case to court. It ends up at the Supreme Court, consolidated with other cases from various states, including Michigan and I think Kentucky, Tennessee. And so, the argument here, once again, in a lot of ways is, do you apply the principles of Loving v. Virginia and interracial marriage to the context of same-sex couples and same-sex marriage? And, one thing to note here with Obergefell is it's not a unanimous decision. It's a 5-4 decision. And so we see a powerful majority opinion and a powerful dissent offering different visions of both what the Constitution protects and what the preferred path of constitutional change should be. So the majority opinion, which is written by Justice Kennedy, effectively says that, this is a lot like Loving v. Virginia. The right to marry remains a fundamental right. It's a fundamental freedom. And basically the principles of Loving v. Virginia should be extended to this situation. Furthermore, he says that the 14th Amendment's promise of equality reinforces those promises of freedom. And so in a way, both the 14th Amendment's promise of freedom and equality fuse together to offer important protections. Then the dissent, and I think probably the dissent that's most often read is by Chief Justice Roberts, but actually each of the dissenters write separate opinions. But what Chief Justice Roberts effectively says is, that marriage has been between a man and a woman for centuries upon centuries. So it's well established through tradition and custom. There's nothing specifically in the Constitution that protects a right to same-sex marriage. The 14th Amendment, maybe Loving, certainly Loving's right. Loving was about race, and the 14th Amendment is paradigmatically about race. So maybe that's different. But finally, Chief Justice Roberts acknowledges the advances that the LGBTQ community were making along many fronts in convincing people that same-sex marriage was a good idea and that people should change their laws. And Chief Justice Roberts argued that by the court stepping in right now, it closes off that democratic process, those democratic debates, and instead it's the court imposing this particular right in a 5-4 decision rather than leaving it to the elected branches. And so it's sort of, in that way, Kerry, sort of a classic battle between, the majority saying the Constitution's text protects this particular right. It doesn't matter what the elected branches have done. It's the role of the courts to enforce the Constitution as we read it. And a more limited view for the courts and of the reach of the Constitution of what we see with Chief Justice Roberts sort of saying, let's leave it to the elected branches and the democratic process because the Constitution doesn't clearly protect this right.
And I think that's the hardest part for all of us to kind of wrap our heads around it. Where when we look at these constitutional questions that the court looked at, that these Supreme Court members looked at in 2015, it's not what should or we shouldn't do, because that is kind of like our personal or our political belief net. But what does the Constitution allow? So with Roberts, it's done it very much like, well, the Constitution allows for this state-by-state growth of change. Leave it alone. That's the way it could have and maybe should have gone. And then there's the other group that, in the majority opinion, that said, nope, we protect. This is just like Loving. We're protecting it. And then the students were asking, what were the other goals around this to say that the Constitution should stay out of it, and this is up to the states to decide. So there's almost like three opinions here: a majority that says the Constitution protects it, and then Robert's minority, and then the other minority. So just clarify that last minority for everybody.
Well, I'm sorry, Kerry, I'm not sure if I understood that question.
So what was the goal of saying that the Constitution, I know what Robert said, but that wasn't the full majority view as well. So what was I guess the question really from the students is, why did the states put this in place in the first place? So the states are saying that it's not the government's job to say who can marry, or that the government is clarifying that a marriage is only between a man and woman, and that's where it should stay. What was the original intent of the laws that prohibited gay marriage?
Yeah, I mean, I'd say the state's argument roughly was, marriage laws fall within the traditional powers of the state. The state can decide who's going to marry under state law. And what we're doing through these state laws is protecting the traditional definition of marriage, which has existed for centuries. And so I think that that's effectively, and then, what the court then has to decide is, one, is there a right to marry in the Constitution? And two, does it apply to Jim Obergefell and his husband? And then three, if it does, is the state giving a good enough reason to justify its law? And so that's sort of how the legal analysis proceeds.
Awesome. And there's a lot there. And again, students, when we think about constitutional questions, we're always going back to, what does the Constitution allow the government, the federal government, and the state governments to do? What's under their jobs and what is not under their jobs? So when we start questions with, well, they should or should not allow this, that's usually a policy or a political question. When we start the question with, may the government do this? That's when we're really diving into those constitutional questions. And that's what we all do together in this class. So Tom, that was an awesome class. We went through a lot in 37 minutes, a little over, but there was a lot of important questions at the end. So I'm going to wrap up, but students, we will stay for after class questions and making sure that your attendance is working. And I have a backup way of doing that as well. So just hang on for 1 second.
Thank you, everyone.